So, hello to everybody who's joining us today. You're very welcome to our webinar on Nigeria's new Copyright Act. This webinar is organised by EIFL, Electronic Information for Libraries, in cooperation with the Nigerian Copyright Commission. My name is Teresa Hackett, and I manage the programme on copyright and libraries. I'll go through a couple of housekeeping items before introducing our three speakers. So the webinar is scheduled for 1 hour. It's being recorded, as you'll know, since you're all logged in, and we will share this recording and the materials afterwards with everybody who has registered. There will also be an opportunity to ask questions, and please use the Q&A function to ask your questions. And my colleague Edwaldus will keep an eye on the Q&A and also on the chat function as well. So the title of our webinar is Nigeria, the best copyright law in the world with respect to libraries, ? And that's the question we'll be addressing today in the session. The context is the new Copyright Act 2022 that was adopted in March 2023. And in terms of copyright law, that's pretty new. So we're calling it the new, it is the new Copyright Act. The Act introduced a wide range of provisions to protect the rights of authors in the digital environment. For example, a new right of communication to the public, new procedures for online enforcement, and the strengthening of rights management. It also has new provisions to guarantee access to protected works for libraries, education, and people with disabilities. And today, our focus is on these limitations and exceptions, in particular, what libraries are allowed to do under the new law. So I'm delighted to introduce our three expert speakers. Dr. John Asen is the Director General of the Nigerian Copyright Commission. A legal scholar and intellectual property enthusiast, he has for over 3 decades been involved in shaping copyright law and policy in Nigeria. He has also participated in regional and international negotiations in the field of copyright, the drafting of the new Nigerian Copyright Act, and is now overseeing its implementation. Jonathan Band is a lawyer who specializes in the application of copyright law to digital technologies, both in the US, where he is based, and around the world. Jonathan has deep substantive knowledge of copyright issues related in particular to libraries, including issues such as digitization, e-lending, and secondary liability. In 2017, he received a Lifetime Achievement Award from the American Library Association for legislative advocacy and legal counsel. And our third speaker is Dr. Desmond Oriahogba, Associate Professor at the Department of Private Law at the University of Western Cape in South Africa. Desmond is an expert collaborator on international projects, including Open Air, the Open African Innovation Research Network. His scholarship includes many topical issues such as artificial intelligence and the law, and the right to research in Africa. In 2023, Desmond co-authored the second edition of the book Intellectual Property Law in Nigeria, Emerging Trends, Theories and Practice. So I'd like to welcome very much our three speakers, and we look forward to hearing from you during the webinar. And with that, I would like to hand over to Dr. John Asen for some opening remarks. John.
Thank you very much, Teresa, and thanks to EIFL for this wonderful opportunity to say a few words before we go into the webinar. First, I must thank the Electronic Information for Libraries, not just for this webinar, but also for being part of the process that led to the emergence of the Copyright Act that was passed in 2022, but signed into law in 2023. So while I resist the temptation at this point to respond to the question posed as the thing, I can, with a sense of modesty, admit that the Copyright Act is one of the best in this part of the world. Some of the provisions are intentional to provide the needed catalyst to grow our thriving creative industry. But like every other law, it must continually adjust to make room for new challenges and global realities. As a commission, we are constantly reminded that we owe a responsibility to all stakeholders in the copyright ecosystem: authors, intermediaries, users, and as a whole. One of the challenges the copyright ecosystem has always been confronted with is how to reconcile the competing and often conflicting interests of its numerous stakeholders. Fortunately, the new Copyright Act provides clear objectives which will guide us in the interpretation and implementation of the provisions. The four cardinal objectives, as captured in Section 1 of the Copyright Act, are: 1, to protect the rights of authors to ensure just rewards and recognition for their intellectual efforts. 2, to provide appropriate limitations and exceptions to guarantee access to creative works. 3, to facilitate Nigeria's compliance with obligations arising from relevant international copyright treaties and conventions. And the fourth one is to enhance the capacity of the Nigerian Copyright Commission to better and more effectively regulate, administer, and enforce the provisions of the Act. So the point must be made from the outset that these objectives are not hierarchical, so they constitute a community of values and ideals that should coexist for the good of all. It is my belief that a law is only as good as its application to all sides and all interests that that law is intended to address. And as I said at the annual general meeting of the Nigerian Library Association in, I think it was 2019, I did say that libraries are not only custodians of knowledge materials, but also major players in the knowledge and education architecture. They are strategic in the balanced and responsible use of the copyright system. Librarians are in the forefront of the use, the promotion, and the protection of copyrights. Hence, the need for greater collaboration to ensure that the copyright system in Nigeria enriches our commonwealth of knowledge while not downgrading or downplaying the rights of authors. So in a world that has come to be knowledge-driven, and it's acknowledged that the importance of sustainability and balance is at the root of all that we do as humanity, it is not surprising that we are witnessing an increase in the call for a copyright system that strikes the right equilibrium between rewarding authors and investors on the one hand, and promoting public interest through wider dissemination and fair access to knowledge materials. The Nigerian Copyright Act, I believe, seeks to achieve these goals in a responsible and equitable manner. I therefore call on librarians to work with the Commission in developing appropriate tools to bring about greater awareness amongst library users, promote greater respect for copyright, and address all forms of copyright infringements and abuses, including what I call the 3 painful Ps: plagiarism, photocopying, and piracy. Libraries play important roles in the society and are one of the key stakeholders in the copyright value chain, as copyright resources are the dominant materials they use in performing their public service mission of supporting teaching, learning, research, and the preservation of knowledge. Librarians daily interface with the public, and as such, could be very useful in advising users of libraries on the legal and ethical use of copyright works. Ultimately, the library user is responsible for his or her actions, but librarians have a duty to provide information about copyright. It is therefore important that the librarian is knowledgeable in copyright matters. This webinar, in my view, is therefore a good opportunity to upgrade the knowledge of librarians and library users. Working with organizations like IFLA, IFLA, and the Nigerian Library Association, and national agencies such as the National Library of Nigeria, the Library Education Council, and others, the Commission will develop a copyright manual for librarians and information centers. Together, let us renew our commitments and demonstrate our resolve to use the copyright system not only as a tool to enrich the author and our commonwealth of knowledge, but also as a mechanism to promote legal access and maintain a sustainable balance in the knowledge ecosystem. Once again, I thank IFLA and all who have worked in the background and the resource persons who are at this seminar. I look forward to a very engaging session with positive outcomes. Thank you. Thank you, Teresa.
So thank you very much, John, for that introduction. And I think you said something that was very important, that which the law is only as good as its application. And as a general observation, I would say from a librarian's perspective, the law is clear and well written. And that's so important when the law is being kind of handed over, if you like, to the stakeholder communities who are tasked with using the law and interpreting the law in support of their daily activities. So we do appreciate that very much. So now I'm going to we'll pass over to Jonathan Band. Jonathan prepared IFL's analysis of the new law, and he will describe its key features for libraries. And I am going to share my screen with Jonathan's slides. And you can tell me if that's all working.
Yep, no, that looks great.
Okay, great. Okay, so Jonathan, over to you. Thank you.
Okay, well, thank you very much, Teresa. And thank you to IFL for having me here. I guess I'm in my son's old bedroom, but I'm still here with all of you. And thank you all for tuning into this. So as Teresa mentioned, I mean, the question is, you know, it's a rhetorical question. Is the new Copyright Act in Nigeria the best copyright law in the world for libraries? And I think it very well might be. I certainly agree with Dr. Sen's notion that it's probably the best copyright law in the world in Africa, but it might in fact be the best in the world for libraries. So next slide, please, so that we can dig into this a bit more. So this just goes over, you know, the law was signed in, the Copyright Act was signed into law in 2023, as we heard. And we then compared that law against IFL's core library exceptions checklist. And you'll find all these materials on the IFL website. And the Copyright Act scored a near perfect score. And it's on that basis, sort of like this objective, you know, comparison of the act against the checklist. So it's on that basis that we're saying that you know, this very well might be the best copyright law, certainly in Africa and perhaps in the world with respect to libraries. Next slide, please. So the question then is, okay, well, what exactly is so good about the Copyright Act? And so now we're going to sort of look through the various provisions to see what's so good about it. So first, as we just heard, you know, these are the objectives of the Act. And critically, the second bullet, and this is in the statute itself. It's not simply in the legislative history or some other supporting document, but this is in the act itself. It says one of its objectives is to provide appropriate limitations and exceptions to guarantee access to creative works. And so having the objective right there, this objective as one of the main objectives of the act, and as we heard, that there's no hierarchy. This is not less important or more important, but it is equally important with the other objectives, such as protecting the rights of authors and facilitating Nigeria's compliance with international treaties. But by sort of putting it up there, it makes it very clear that the exceptions are to be taken seriously, and that's important as judges interpret the law and apply the law. It's important for stakeholders as they seek to comply with the law. And so, so right from the get-go, it's clear that the exceptions and limitations are to be taken seriously. Next, please. So the core exception that applies to libraries is Section 25. This is a new section, and it in some of its thoughts are arguably derived from the Eiffel Draft Law on Copyright. The copyright exception contained in that draft law, and it applies not only to libraries but also to galleries, archives, and museums. And so the acronym for that is GLAMS, because we're in the library world, we're so glamorous. It permits the GLAMS to make and distribute copies for preservation, replacement, and ordinary GLAM activities. It's technologically neutral. And in a moment, we'll see, it's relatively comprehensive. And so, this is, really a very useful and important provision that not only will be extremely beneficial to GLAMs in Nigeria, but I think also will serve as a model in Africa and elsewhere for the way these kinds of exceptions should be drafted. So next slide, please, so that we can drill down a bit more into Section 25. So first, it allows the making of copies for purposes of backup and preservation. And again, it's technologically neutral. It doesn't say, it's not focused on reprographic reproduction. It doesn't have a certain number of copies. It doesn't talk about that you have to wait until the work is already deteriorating before you're able to engage in that preservation. And in that sense, this focus on, by allowing preemptive preservation, by being broad enough to permit preemptive preservation, it anticipates the WIPO preservation toolkit, which was just issued last month. And a big part of that toolkit talks about the importance of preemptive preservation. So preserving, making, in essence, sort of like backup copies, especially digitally, that you can maybe save in the cloud, is important to do before the works deteriorate or disappear, before you have floods or fires, because if you don't do it preemptively, you will lose it. And so the Section 25 allows that kind of a preemptive preservation. It allows copying a missing part of a work in your collection you can borrow a copy from another collection, another library, and make a copy of the missing parts. You can engage in format shifting where a work cannot reasonably be acquired in a desired format from a publisher. And again, this shows the balancing of different interests. If it is reasonably available from the publisher, then you need to buy the copy from them. But if the copy cannot be reasonably acquired in the proper format from the publisher, the library or the archive, museum, gallery can make a copy in the appropriate format. It allows making of copies of orphan works and out-of-commerce works. And importantly, all of these copies can be lent to users so they can access them outside the premises or be viewed by users on the premises. So again, very broad, comprehensive exception for libraries. Next, please. Section 26 deals with people with print disabilities. It is the implementation of the Marrakesh Treaty, which Nigeria has joined. It allows libraries and other authorized entities in Nigeria to make and distribute accessible format copies, and importantly, included across borders. This is critical to eliminate the book famine, which is the underlying purpose of the Marrakesh Treaty, which is to eliminate the shortage of books that are available in a format accessible to people with print disabilities. And by both joining the Marrakesh Treaty and then implementing it in this fashion, libraries in Nigeria can participate in global accessible book services such as the WIPO, ABC, the Accessible Book Consortium, which enables authorized entities around the world to exchange works digitally, and that allows, let's say a student in Nigeria with a print disability to access a work from the Library of Congress, the national, the division of the Library of Congress here in the United States that provides, makes works that are accessible, so it can be digitally transmitted from the United States to Nigeria, so the student can have access to that work. So this is a very important feature. And again, what's so good about Section 26 is that it takes full advantage of the Marrakesh Treaty, and it's faithful to it, and it sort of allows Nigeria to participate in all this right away. Next, please. So in addition to those specific exceptions, the new act amends the pre-existing fair dealing provision. So the Copyright Act had a fair dealing provision that's ultimately based on the English copyright law from, I think it's 1910 or 1911. But that law was a bit rigid, and what the amendment in the new act allows greater flexibility, and also, but at the same time provides guidelines about how to apply this increased flexibility. So this will enable libraries to engage in all sorts of activities, such as, let's say, web archiving, which might not already fall within other provisions such as Section 25 or 26. It provides the flexibility for potential uses that are not yet foreseen. We're now in a time of rapid technological development, and it's impossible for a legislature to, at any point in time, to foresee everything that might be done in the future. And it's important to have the flexibility so that users can make those uses, and but they have a sense of what are the parameters, and then those can be challenged in court if necessary. But courts then have again parameters under which to assess the fairness, and all of this revised and amended fair dealing provision is similar to fair use and fair dealing provisions in countries such as the United States and Singapore and Korea and elsewhere. and those are fully compliant with the Berne Convention and TRIPS, and so they don't cause any problems for Nigeria with respect to its treaty obligations. Next, please. It also retained pre-existing provisions, most importantly, the library lending. So Section 9 of the Act is again the old provision dealing with distribution, but it allowed library lending, and so libraries can continue to lend. It doesn't introduce a public lending right, which is very problematic from the perspective of libraries. It also allows the importation of non-infringing copies. As before, this is important for libraries to be able to develop their collection so that they can, if there's books overseas that are not available domestically, they can buy and import those books so long as they're non-infringing copies. And the pre-existing library exception is retained, and so that also has certain benefits. Next, please. Now, importantly, it has all of these exceptions, and those are great, but it makes sure that these exceptions cannot be overridden. So digital content is typically distributed under a license agreement, and the license agreement might say that the licensee, in this case, the library, cannot make a copy for any purpose whatsoever. And that would then become in conflict with Section 25, let's say, with all the exceptions under Section 25, or the exceptions in Section 26 for people with print disabilities or fair dealing. And so Section 23 makes clear that it renders null and void any license term that is inconsistent with an exception. In other words, it makes clear that the exceptions trump all of these, any license term to the contrary. And this preventing contractual override or protecting exceptions from contractual override is very important. Other countries have started introducing those provisions. Singapore, Kuwait, the Cook Islands, many EU member states have it with respect to some exceptions, as well as the UK. What's good about particularly good about the Nigerian provision, that it applies to all exceptions. It's in that sense, it's better than the EU provisions, which are only apply to certain exceptions. So that's a very important provision. And then the second thing is that Section 50 now prohibits the circumvention of digital locks, and this is one of the features of the Act that is intended to benefit rights holders. But again, that could be in tension with the various exceptions. Let's say a library wants to circumvent a digital lock in order to make a non-infringing copy, for example, a preservation copy. If you again would have a tension, which prevails, the prohibition on the circumvention or the exception. And Section 57 anticipates this issue, and it prevents the circumvention of digital locks for the purpose of exercising exceptions. So that's, again, a very important feature protecting these exceptions that have been adopted. Next, please. So all of these exceptions, we scored it against the Eiffel Core Library Exceptions Checklist, and the copyright law scored 34 out of a possible 36. So when I was in school and I did well on a test, I was a good student. I would come home, I'd be very proud, and I'd tell my parents I got a 97 on a test out of 100 or 96. And instead of complimenting me on that, my father would always say, okay, well, do you know what points you missed? And do you understand what you missed? Do you understand what you did wrong? So it's important to understand what's missing from the checklist relative to the checklist. And so the copyright law lost 2 points because it does not protect librarians from being sued when acting in the course of their duties. It doesn't have like a limitation on liability. Now, the truth is very, very few countries have that. The United States and only a handful of other countries have it. And while, it's unfortunate that we don't have this, it's really not that serious a problem because the exceptions are so good. You need to have this protection from liability if your exceptions are ambiguous or limited. But because the exceptions here are so good, I don't see this as a serious problem in any respect for librarians and their exercising of their duties. Next, please. So these are the various things we've been talking about, the various references. So they're on, you can find them on the IFL website. There's this whole document about what libraries in Nigeria can do under the 2022 Act. Then you can see the checklist and also the draft law on copyright. So thank you very much for your attention, and I'm happy later on to participate and answer your questions. Thank you.
So thank you very much, Jonathan. Thanks for that very concise overview. And while you were presenting, we put a link into the chat to the text of the Copyright Act on WIPO Lex. So for anyone who wants to follow the sections that Jonathan was describing, we will also share Jonathan's slides with participants afterwards, and we'll share a link to those resources that Jonathan talked about. I also encourage you to put any questions that you might have into the Q&A function, and then we'll be glad to take those questions after our final speaker, who is Dr. Desmond Oriahoba, who will provide us with a short commentary on the law from an African and an access to knowledge perspective. So Des, the floor is yours. Thank you.
Thank you very much, Teresa, for the invitation, and to IFL for this, for putting together this wonderful webinar in conjunction with the Nigerian Copyright Commission. Now, the beauty about speaking last is that you would have very little to say because the wonderful speakers before you would have said everything. And I'm going to stand on what has been said already, the fantastic analysis of the Copyright Act, Nigerian Copyright Act by Jonathan Band from a library perspective, and the very insightful open remarks by Dr. Aseng. One thing I take from the two conversations is that the objectives of the Act in Section 1, it's a mix of the core value of the provisions that follow in the Act, and these values, according to what the previous speakers have said, are of equal parity. None of the values take precedence over the others, which means that in looking at the Copyright Act, you must look at all the provisions as it relates to all the stakeholders. However, the conversation today is the provisions of the Act as it relates to GLAM, as it were. Now, as an academic, and speaking for myself, when I engage with Copyright Act, I look at for one key thing: balance. And for me, the balance here in this circumstance relates to whether the interest of right owners, that is their ability, the opportunity for them to gain reward from their creativity, is protected adequately by the law. And on the other hand, whether the interest of the public with regards to making sure that users of creative outputs have access to information embedded in those creative outputs for the overall development of creativity and culture in the particular society, whether those interests are also protected. And of course, from all the conversations so far, we can say without missing words that the Nigerian Copyright Act, the 2022 Act, simply, achieved that purpose, balance with panache and with, effectiveness. So for me, I would then simply look at it from two broad perspectives as to its importance, its relevance within the African context. I've already talked about question of access to knowledge. The Act achieves that. It will help Nigeria to navigate those issues of access to information, which is to obviously still be devil's the country, especially from the context of access to learning and teaching materials. On the continent broadly, the Act is important because there are some countries in Africa are they are currently undergoing copyright reform. And so what that means is that apart from the Act, joining the previous speakers, apart from the Act being about the best in this part of the world, and probably the best, globally, apart from it being the best, it can also serve as a model, for the other countries in Africa that are currently undergoing copyright reform. And just to name a few, South Africa, Zimbabwe, Namibia, and also I think Uganda are at different stages of their copyright reform process. For South Africa in particular, I am very much aware that the South African Copyright Amendment Bill has gone through Parliament, and it's now awaits assent by the South African president. Of course, it's electioneering period, and it is still very uncertain as to whether the bill will be assented now or in the nearest future. But we're not talking about South Africa, we're talking about Nigeria. I'm only bringing this up because, like I said, the Nigerian Copyright Act can serve as a model. How will it serve as a model to South Africa? Since the Copyright Amendment Bill in South Africa has already been passed, it will simply serve to encourage and serve as a reference point for the president, to go through the whole issues, the whole arguments about whether the Copyright Amendment Bill is good for the creative industry in South Africa or whether it is bad for the creative industry in South Africa. Go through all those and say, look, we have a country in Africa that's more like the leading country in terms of creativity, in terms of entertainment, in terms of the creative industry in Africa. It has this wonderful provisions that are being contested in South Africa in its new act. If it could include those provisions in its act, then it then sends one signal that they are not as bad as they are being portrayed within the South African context. So, simply put, the Nigerian Copyright Act would then serve as a model in that regard. Refer to it and sign the Copyright Amendment Bill in South Africa and it's in law. At the continental level, actually, in February 2023, the IP rights protocol to the agreement establishing the African Continental Free Trade Area was adopted. And that protocol has high-level provisions, very high-level provisions relating to copyright, and that you find that in Article 11. In Article 17, you also find very high-level provisions relating to emerging technologies. Of course, emerging technologies here in mind, I have artificial intelligence. What these provisions do, like I said, they are high-level. They even though they are high-level, they provide a framework for achieving the balance, which I spoke about at the beginning of my speech. Member states have committed to, ensure the protection of the rights of creators, the rights of authors and owners of copyright. They have also committed to, ensure protection of emerging technologies. On the other hand, they have also committed to ensure, protection of that space for access to information, for the promotion of emerging technologies and also for the promotion of the creative industry. But because the provisions are high level, member states then commit to abide by additional obligations that would be included in annexes, that they will eventually negotiate. So Now, this is where the Nigerian Copyright Act becomes very important. If you take your mind back to the conversation, to the presentation of Jonathan, and from a library perspective, you would agree with me that the act itself, within the space of the IP protocol to the AFCFTA, the act can also serve as a reference point, serve as a model for, protocols for annexes that will be negotiated to make specific provisions to give life to the broad high-level provisions that are contained in the AFCFTA IP protocol. Beyond that protocol, I mean, I think sometime in 2023, WIPO adopted a proposal for a work program that was actually proposed by the African group in WIPO, work program on limitations and exceptions. Even though there is no express commitment on developing international instruments, on working towards developing international instruments for limitations and exceptions, especially for education and research. The work program would definitely draw heavily from the Nigerian experience. The work program requires that member states should embark on studies. Member states should develop toolkits, especially. Now, in developing those toolkits, they can draw heavily from what we have under the Nigerian Copyright Act, the new Copyright Act, to develop toolkits for limitations and exceptions, especially in relation to library, to education and research, and the work of galleries, libraries, archives, and museums. So, in summary, I would say that apart from being the best in Africa, the Copyright Amendment Bill, in my view, and speaking as an academic and one who has also studied the Act and written on it, the Copyright Act, 2022, the Nigerian Copyright Act would serve as a model for nations that are reforming their copyright laws in Africa, and also for the implementation of the AFCFTA IPR protocol and the WIPO work program on exceptions and limitations. I'll stop here. Thanks, Teresa.
Okay, well, thanks very much, Desmond, and thank you for bringing in the importance of the law, not only in Nigeria, and the relevance of the law not only in Nigeria, but also in the wider context of Africa, and the discussions also that are happening at the international level as well. So with that now, we can turn over to you, the audience, for your questions and your comments. So we have a number of questions that have come in on the Q&A. So I'm going to start with, let's start perhaps just with the first question, which was a practical question, and maybe I'll ask Jonathan to take that, and you're already on camera, so thanks, Jonathan. So that was a question about the use of the Act. Are there provisions for libraries to stream videos and audio clips in your...
Well, I took advantage of the question already having been posed. So while Desmond was speaking, I quickly double-checked the Act, and under Section 25, that it's not directly addressed because those aren't, that's not a specific situation discussed under Section 25, but that is exactly the kind of use that conceivably would be permitted under certain circumstances by Article 20, by the fair use, or the revised fair dealing provision. Also, I guess one could make an argument that under Section 25, if there was a preservation copy made of a film, then perhaps that could be streamed to an individual user as opposed to lent to the user. Certainly Section 25 says you could lend the preserved copy to the user, but whether that would allow streaming or whether you'd really need to rely on Section 20 fair dealing to allow that streaming would be an open question. But again, that's a perfect example of how you can look at these things in tandem and say, well, maybe maybe under Section 25, but if Section 25 doesn't quite get you there, then it's likely permitted under Section 20.
Okay, Jonathan, thank you. The next couple of questions I think I might address to John, since they're related to perhaps more the operation of the law, and how the Copyright Act was introduced. So the first question is about the introduction of the exceptions. Was opposition raised by authors or creators to any of the exceptions, especially the expansion of fair dealing? The next question, also maybe you could take a look at this one. Librarians need to cooperate with creators of IP in the area of reprographic licensing, especially for universities. And then the third question could be, it is good that we've looked at the sections, but is there a need to consider the true implementation of the law outside of the library system? So this is a question about, if agreed, what is the level of enforcement or control? So John, perhaps you might be able to help us on those questions. Thank you.
Oh, sorry, Teresa, were those for me?
Yes, if that's possible.
Okay, well, I mean, Desmond will be able to respond to any question from Nigeria. But if it's about the enforcement side of it, I think you said something about the enforcement, right? Yeah, I mean,
Sorry,
what I would say is, like I said in my remarks, the Nigerian Copyright Commission will certainly step up enforcement, because we see that as a responsibility that comes with the new Copyright Act. But as we step up enforcement, we also step up providing users with what I call means of using copyright works legally. Just as we are providing safe corridors for right owners, we also encourage every user to be able to take advantage of any exception that is available in a responsible manner, as the law provides for. So the Commission will do more as we move, onto the implementation stage to ensure that there's full enforcement.
Okay, thank you, John. That did. And there was one other question just asking about the exceptions, and was there opposition from rights holders or creators to the exceptions that as they were being adopted in the Act?
Well, I think one would expect not oppositions, but expressions of concerns. I believe that in striking the balance, you will always have the right owners expressing concerns. You'll have the users expressing concerns. And I would say that this is probably the first time in a long while that we've had users also being represented. In the old Copyright Act, when we're drafting it, there was a preponderance of right owners around the table. But this time around, we have both the right owners and those representing the interest of users. So yes, there were concerns, if you could call them opposition, but those are to be expected in any lawmaking process. And we've always tried to explain to them that we must strike that balance. And Section 1 of the Act makes it, should be comforting for everyone that those 4 objectives are going to guide us in implementing the provisions of the Act.
Okay, thank you very much.
Okay.
Welcome.
Right, Teresa?
Yes, Desmond?
Okay, maybe I should just add to what Dr. Hussain has said and then respond to one, I think it's a comment, but looks like a question. I was privileged, to study some of the comments that were sent in during the lawmaking process, and also was privileged to be at one of the public hearing for the bill before it became an act, for the bill organized by the National Assembly in Nigeria. And I can say that, yes, like Dr. Hussain said, concerns were raised. But what struck me most is the way and manner that the lawmakers, including the Nigerian Copyright Commission, I'm not speaking for them, were able to balance these concerns, both from creators and from users. we're able to navigate the thorny issues that came up along the ways, and then we're able to provide to produce for us this very wonderful act that we are celebrating today. The second thing I wanted to respond to is a comment, and somebody says, I appreciate the analysis of the Nigerian Copyright Act. However, librarians need to cooperate with creators. Like has been said during the presentation, the act, even though we're talking about library today and librarians, the act is for everyone. So the act actually has provisions for creation, establishment, and regulation of collecting societies, reprographic organizations, and there is actually one in Nigeria, ReproNIC. The provisions of the act has, makes room for instances where the libraries and where libraries need to access materials outside the exceptions. And to that extent, of course, I agree that they would have to cooperate with, to the extent that whatever they are accessing, information they are accessing is not within the exceptions that have been talked about today. I agree that, yes, they would have to cooperate with ReproNIC for licensing purposes. Thank you, Teresa.
Okay, thank you. Thanks, Desmond. Jonathan, you've raised your hand, and I'm going to also line you up for the next question as well on the topic of orphan works. Thank you.
Sure. So just with respect to that question about reprographic reproductions and so forth, there is another exception, Section 23, that deals with educational institutions and what they can do. And so, in our analysis, we didn't, look at every possible use a library could be making in every possible context. So certainly, in educational, libraries and educational institutions, you'd have to look at, what are they allowed to do under Section 25, but then you'd have to say, okay, well, what's, given the situation of sort of making multiple copies for classroom uses, that wouldn't necessarily be under, not always the libraries making it. It could be an instructor making it or someone else in the institution. You'd look at that under Section 23, but again, not only 23, but also Section 20 fair dealing, so that it's, you see what's permitted under 23, and if it's not permitted under 23 and it's not permitted under fair dealing, then you would enter into a licensing situation. And certainly, if you're doing, large scale copying, making copies of lots and lots of material for lots and lots of students, then licensing would most likely be what would be required, and that it would not fit under any of the other exceptions.
Okay, thank you, Jonathan. And can I ask, while you're here, that you take a look at the question from Olaf Stockmo on orphan works. So you referred to the Act allowing the reproduction and use of orphan and out of commerce works, if he understood correctly, and if so, could Olaf ask you to direct to the specific provisions in the Act which would allow that? Or did you understand?
Yes. So if you look at Section 25(1) E, and that would seem to that deals, I'm interpreting that deals with orphan works or out of commerce works, because it says, they can make a copy when you cannot make or procure a copy of any work where permission of the owner or of the copyright cannot be obtained after reasonable effort, or where the work is not available by general trade or from the publisher. So again, that would be Section 25, Roman numeral 1A. No, I'm sorry, Roman numeral 1 E. Okay, so Section 25, Roman numeral 1 E addresses that issue.
Okay, thank you, Jonathan. And the following question also deals with the issue of orphan works, and I think, Jonathan, you've probably just answered that question as well. There was one part of the other question is about how does the new Act handle obsolete concepts remnant from historical UK premised Copyright Acts, for example, unpublished works? Would anybody like to respond to that?
Well, I can make a stab at it. It's again, you know, you would I would think that different parts of you know, depending on the exact fact pattern, different parts of Section 25 would come into play. I mean, certainly if it's you know, if you're missing parts of it, then you could borrow parts from somewhere else. If you have your copy, but you're worried about its deterioration, you can make a backup and preservation copy. And then in addition to, you know, if the specific use you're trying to make, or again, you know, as we just said, just this orphan work provision or the out of commerce, you know, you kind of look and try to see whether the activity you want to make falls within one of those categories. Also, another category that we haven't really talked much about, but I mentioned briefly, is you're allowed to make and distribute copies of works as part of ordinary activities. And so that's ambiguous. What is the ordinary activity of a library? But if you're able to make a case, or you think you're comfortable, if the library feels comfortable arguing that this activity is part of its ordinary activities, then you know, you could make a copy into that provision. So there's several different, you know, depending on the exact fact pattern, you would have several different ways to make a lawful copy.
Okay, thank you, Jonathan. So I've just put I'm just about to put a link into the chat here to the Eiffel Guide, which Jonathan described, which goes into some of these questions in more detail. So in that checklist, there are, you know, specific questions. Does the Act allow a certain activity? And then it gives a reference to that section of the Act. So that might be helpful in identifying some of the provisions that we've been referring to. Now I'm looking at the clock, and as we are approaching the end of our webinar, I would just like to ask if our speakers have any final comments that they would like to make before we close. And if not, then we will finish this webinar. I'd like to congratulate the Nigerian Copyright Commission for achieving the new copyright law that sets the bar for not only in Africa, but also for the rest of the world. I'd like to thank the speakers for attending. So Dr. John Essene, Dr. Desmond Oriahoba, and Jonathan Band. And I'd like to thank you, the audience, also for attending. We will share the recording. We will share Jonathan's slides afterwards, and also the Eiffel Guide and the other resources that Jonathan referred to. So John, I'd like to just give you the final farewell word before we leave. Thank you.
Well, thank you so much, Teresa. I mean, nothing much to say except to thank you again for this wonderful opportunity, and to thank Jonathan and Desmond for weighing in and bringing their expertise to bear. I want to assure the librarians and everyone out there that is concerned that the Nigerian Copyright Commission will work harder to engage and spread the knowledge. But above all, we're going to use the Copyright Act in the most responsible manner. And even though we want to, you know, disseminate knowledge, we also will always respect the rights of authors and find a balanced way of enforcing if we have to. So thank you so much for this opportunity, and we're going to do it again. And I hope we'll find you to support us when we do that. Thank you.
Sure, it's the start of a conversation. Okay,
It is.
so thank you, everybody. Good morning or good afternoon, wherever you are in the world. And thank you so much for joining us. And good day.